Honourable members, when we took the suspension last evening, I had asked for an opportunity to be able to analyse the arguments that I had heard arising out of an objection formally laid by the Honourable Attorney General to Mr. Ramjattan's motion concerning amendments. With your leave and permission, I'd like to read my ruling. But before I do so, I'd like to apologize for the delay as the clerk and I were going through it to make corrections. I believe it best that I read the ruling. The ruling is entitled Reference Number 4 of 2013, ruling on the admissibility of a motion in the name of the Honourable Member, Mr. Khemraj Ramjattan, MP, to amend the 2013 budgetary estimates. In 2012, during the consideration of the estimates accompanying the 2012 budget, the Committee of Supply, by way of a simple majority vote, amended the estimates presented by the Minister of Finance by removing a total of $20.9 billion from within various heads of the budget. The Minister of Finance, in proposing the appropriation bill, Bill number 3 of 2012, to be taken through its 3 stages, reported that the Assembly had approved the bill as amended. After much angst, confusion and distress, the 2012 budget of the government was approved with amendments. That it was unanimously accepted that the National Assembly had the power to amend the estimates in 2012 was never in any doubt, as even the Minister of Finance, the Honourable Dr. Ashley K. Singh MP, stated on the 17th of April 2012, and I quote him, "Over the next 6 days, we will be considering the national estimates, and it is the legitimate right of the opposition to ask any questions it wishes within the standing orders in relation to those numbers. It is indeed the legitimate right of the opposition to propose any change within the boundaries of the standing orders to any of those numbers," end of quote. Understandably, and as was repeated last night, the Honourable Minister stated that at that time we were collectively in uncharted waters, and that he did so without the benefit of the collective experience of all, and without the matter being put to the ultimate test, that is of being scrutinized by the High Court. Subsequently, on June 4, 2012, the Honourable Anil Nandlal, Member of Parliament and the Attorney General, instituted civil proceedings number 216W of 2012, Demerara, a generally endorsed writ, to challenge the validity of the amendments passed by the National Assembly. And on July 18, 2012, the London Chief Justice, the Honourable Ian N. Chang, CCHSC, hereinafter the Chief Justice, gave a preliminary ruling that emanated from an ex parte application filed by the Honourable Attorney General, asking for the Honourable Finance Minister, Dr. Singh, the third named defendant, to be, and I quote, "to be at liberty to make advances or withdrawals from the contingencies fund pursuant to Article 220 of the Constitution for the purpose of restoring the funds to the agencies as originally budgeted in the estimates of the revenues and expenditures of Guyana for the year 2012, end of quote. As far as could be ascertained, since the date of the provisional ruling, no further steps have been taken, and the court is yet to make a final ruling on this very critical matter. On Friday, April 12, 2013, as per the procedures laid down in the standing orders, as was the case in 2012, notice of motion for amendments was received in proper form from the Honourable Mr. Khemraj Ramjattan, MP. And on Monday, 15th April 2013, in view of the point of order formally raised by the Honourable Attorney General to the motion in the name of Mr. Ramjattan, whether or not it was properly on the notice paper for consideration, and as Speaker, being in my view the authority to decide on the due regularity of motions based on standing orders 26 and 27, I invited arguments for and against the motion being introduced. Previous rulings numbers 2 and 5 of 2012, given on the 15th of March 2012 and 13th of June 2012 respectively by me as Speaker, have established that in strict compliance with the doctrine of separation of powers, the executive has the right only, and only the right resides in the executive to formulate the budget, and correspondingly, the National Assembly has the right to scrutinize, approve, disapprove, or amend by reducing only the government's estimates of expenditure. In a manner of speaking, therefore, this ruling is an expansion and continuation of numbers 2 and 5 of 2012, respectively. For the sake of clarity, I have identified the essence of the arguments of the two sides of the House to be, on the government side, Firstly, that the word approved must be given its literal meaning and interpretation and can never mean amend. Secondly, that the power to amend would have been explicitly granted to this National Assembly if this is what the framers of our Constitution intended. The words would have been so set out as they are in Article 113(2) of the Constitution of India. Thirdly, the Ghana situation of the National Assembly amending estimates was never contemplated given the unique political system that includes features of a hybrid Westminster presidential system and proportional representation. And further, the constitutional reform process of 1998 to 2001 neglected to address this anomaly. Fourthly, that the Constitution of Ghana is supreme and all institutions of state, including the National Assembly, are subject to it. Fifthly, that the High Court, as the only institution that can interpret and make binding declarations on the Constitution, has, through the Honorable Chief Justice, made a ruling that must be followed by this National Assembly. And sixthly, that Article 171, 2A and B have no applicability to the consideration of proposed estimates, but rather relate only to existing charges on the consolidated fund. In turn, the opposition's arguments I discern to be: 1, that the power to approve must include the power to amend. 2, that the majority of the National Assembly is empowered to make changes to the estimates. Thirdly, the Honorable Chief Justice's ruling was restricted to just one matter, being whether the Minister of Finance could make advances and withdrawals from the contingency and consolidated funds. Fourthly, that the High Court has no jurisdiction to interfere with the National Assembly in the performance of its functions, and that the High Court's constitutional duty and responsibility commence after the National Assembly has acted. Fifthly, that the ruling of the High Court did not strike down the Parliament of Guyana's decision to pass Appropriation Act No. 3 of 2012. And lastly, sixthly, that the National Assembly has the power to amend the estimates in the Committee of Supply stage and also to amend the appropriation bill when it is being considered. I turn to the principle of budgetary control. Ever since the 17th century, the battle of the purse, as it is referred to, began in the United Kingdom, and the outcomes are such that for countries that were former British colonies, these were inextricably affected and influenced unto today by the manner of their constitutional arrangements governing public finance. Many lives were lost and monarchs deposed over this issue about parliamentary supremacy and the right to approve budgetary allocations for the crown. The Glorious Revolution of 1688 comprehensively defined the financial role of Parliament as it culminated in the promulgation of the 1689 Bill of Rights, which established that the principle that only Parliament could authorize taxation by proclaiming, and I quote, that levying money for or for the use of the crown by pretense of prerogative without grant of Parliament for longer time or in other manner than the same is or shall be granted is illegal, end of quote. Former Prime Minister of Great Britain, William Gladstone, had since 1891 defined the power of Parliament over public spending this way. And Prime Minister Gladstone said, the finance of the country is ultimately associated with the liberties of the country. If the House of Commons by any possibility lose the power of the control of the grants of public money, depend upon it, he said, your very liberty will be worth very little in comparison. That powerful leverage has been what is commonly known as the power of the purse, the control of the House of Commons over public expenditure, end of quote. And more recently, an Australian Senator Andrew Murray in 2007 stated, and he says, the transparency and accountability of Commonwealth public spending and expenditure is right at the very heart of parliamentary life. Those who understand the history of parliaments know that this is the battlefield on which hundreds and thousands of people have lost their lives. It is about the right of the people to determine how they are to be taxed and how that taxation is to be spent by those who govern them. The fact that the history of striving for good government goes back centuries and is steeped in blood should remind us that, as dull as this may seem to those who seek other pastures of interest, this is material which goes right to the very heart of our parliamentary function, end of quote. The very senator also wrote in a paper entitled Budgets and Finance, Sunlights and the Dark Arts, wrote the following words. Democracies, he says, are weary of a concentration of power and the abuse of power. If Parliament controlled its own budget, it would advance the separation of powers. Democracies try to keep separate the Parliament's power to make laws and to tax, from the executive's power to propose laws and to spend the revenue, from the bureaucracy's power to administer laws and programs, and from the judiciary's power to determine disputes according to law. Each of these is meant to act as a check and balance on the other. But if the executive holds the financial resources and the whip hand, then there is great imbalance in power. End of quote. Today, the position that the People's Representative Assemblies must have the right to raise taxes and to approve spending by governments is well settled and established. Erskine May captures the essence of the principle this way, quoting from Erskine May, the 23rd edition, says, "The dominant influence enjoyed by the House of Commons within Parliament may be ascribed principally to its status as an elected assembly, the members of which serve as the chosen representatives of the people. As such, the House of Commons possesses the most important power vested in any branch of the legislature. That is the right of imposing taxes upon the people and of voting money for the public service." In Guyana, despite having a unicameral legislature, a hybrid of the Westminster system and proportional representation, it is my considered opinion that the principle of representatives of the people is no less potent and is very valid and alive. There are several well-recognized universal principles and tenets that inform the function of parliamentary control over public money. These include: 1. The executive cannot levy taxes or borrow monies without the legislature's authority. 2. The executive has spending authority only when it has received such authority from the legislature and in accordance with the limitations stipulated by the legislature. 3. Each year, the legislature grants, through appropriation acts, approval to the executive to spend monies on these expenditure items for which approval has not already been given, and normally for all other expenditures other than statutory items. And 4, the executive must submit an annual budget of expenditure, which are called estimates, to the legislature. One writer, Mr. Joachim Wiener, who is a lecturer at the London School of Economics, observed that many legislatures have constitutionally unfettered powers to shape budgets, including those in Scandinavia, much of continental Europe, and the United States. To the contrary, he says, reductions-only restrictions apply in the Westminster tradition, so that Parliament may only reduce existing items, but it may not include new ones or increase existing ones. Finally, he says, the Westminster tradition precludes a creative role for Parliament in budget policy through the amendment process. Any amount from an expenditure item that is cut cannot be shifted to increase spending on a different item elsewhere in the budget. End of quote. Even in the face of what many consider to be clear and defined rules, the matter of the right of Parliament to exercise control over public spending is one that continues to generate tension and confusion. The relationship between the legislature and the executive and the powers over public spending vary from region to region and from country to country. The varying systems deployed are the subject of much debate and even judicial intervention. A 2003 National Democratic Institute paper traces the various systems used to regulate this delicate balance and the tense situations these evoke from time to time. And in that paper, it is said that in almost all political systems, it is generally accepted that the executive has a primary role in developing an annual budget and presenting it to the legislature. The legislature has the right to review, debate, and in some cases amend and approve or reject the spending plan proposed by the executive. In developed presidential and parliamentary systems, the executive and legislative branches have traditionally struggled to find an equitable balance of power over financial matters. That struggle continues today, as executives and legislatures seek to exercise their budgetary prerogatives, fashion new ones, and mold policies through the allocation of the nation's resources to priority programs. And similarly, in a paper entitled The Role of Parliament in the Budget Process by Warren Krafchick and the very Joachim Wiener who I referred to earlier, the authors boldly advance the position that, and I quote, as representatives of the people, Parliament is the appropriate place to ensure that the budget best matches the nation's needs with available resources. The international debate is framed as a tension between the roles of the executive and the legislature, between technicality and democracy. In virtually all countries, it is accepted that the executive has a mandate to prepare the budget. The role of the legislature is to exercise oversight and to authorize the executive to raise revenue and spend money. And finally, Mrs. R.A. Amodu from Nigeria, I believe she is known as the Secretary General, or for comparatively the Clerk of the Parliament of Nigeria. Writing in a paper entitled The Appropriation Procedure, an Aspect of Budgetary Process in Nigeria in 2001, wrote, in virtually all parliaments of the world, there is common provision in their country's constitutions as to whose duty or responsibility it is to pass laws. This duty is invariably bestowed on the legislature. The responsibility is indeed more pronounced in regard to money matters, that is, appropriations and finance, including even bills whose subsidiary elements involve money. In order, however, to implement the constitutional provisions in practice, parliaments employ rules and regulations, commonly known as rules, standing rules, or standing orders, which are generally similar for legislatures in democratic countries, but may vary in operational details. I turn now to Guyana. In the 1960s, being the era of self-determination, Guyana, like scores of foreign British colonies, received political independence, but not without being given the tools to organize and govern the state, which we know as a written Westminster-type constitution. Most former colonies have altered and refined their original independence constitutions. Ghana is no exception, as in 1970, 1980, and in 2001, Ghana's constitution received substantial amendments. Nevertheless, the portions dealing with public spending and finance have remained virtually untouched. The regime that regulates the various aspects of public spending can be founded largely in three primary instruments, being firstly the Constitution, secondly the Fiscal Management and Accountability Act, and thirdly the Standing Orders of the National Assembly. The relevant sections and articles of these instruments are set out in schedules to my ruling and are attached. But for the Constitution, the relevant provisions are Articles 171, 218, and 219. For the Fiscal Management and Accountability Act, it's Sections 16 and 17. And for the Standing Orders of the National Assembly, it is Standing Orders 71, 75, 76, and 77. Article 9 of the Constitution, interestingly, recognizes, in my view, the legality of the Standing Orders of the National Assembly when it says, the rules and orders of the existing Assembly as enforced immediately before the appointed day shall, unless it is otherwise provided for under Article 165 and 173 of the Constitution, as the case may be the rules of procedure of the National Assembly and of the Supreme Congress of the people established under the Constitution, but shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution. Parliament, in its wisdom, went further by placing into the Constitution the following in Article 1651, and I quote, that subject to the provisions of the Constitution, the National Assembly may regulate its own procedure and make rules for that purpose. It is opposite to note that in a ruling given by the Honourable Speaker Ramjattan in the 9th Parliament, arising out of a point of order raised by Mr. Anand Nandlal MP, as he then was, on the legislative potency of the standing orders, the Speaker ruled thus, and I quote him, I therefore disagree with Mr. Nandlal and rule that the standing orders fall within the definition of written laws. Then Mr. Ramjattan was using the interpretations given to him by the Interpretation General Clauses Act, Chapter 201 of the Laws of Guyana. I endorse this ruling. The relevant standing orders relating to the business of parliamentary scrutiny and approval of finance bills are set out in Standing Orders 71, 72, 73, 74, 75, 76, 77, 78, and 79. I turn briefly to what obtains in other jurisdictions. Reference has already been made to the fact that in all instances, save one, And that one where the exception is New Zealand, where I pointed out last night that there is no written constitution, but for every other colony of Great Britain, there is a written constitution quite similar to the one that we inherited in 1966. In all those instances, save one, the regime and architecture for financing government spending is for all intents and purposes the same. To this end, reviews have been made of the Constitution and standing orders of parliaments and assemblies in other jurisdictions with a Westminster tradition and a written constitution. In those reviewed as a representative sample of all, I looked at Trinidad and Tobago, Jamaica, Canada, New Zealand, India, Ghana, Singapore, Sri Lanka, and even Nigeria. And in all, the power to amend financial statements is recognized and upheld. Only recently, in March of 2013, that would be last month in Singapore, the Parliament passed the government's budget, but not before a gargantuan number of motions, 483 to be exact, motions for amendments were submitted. A gargantuan number was submitted, 483, even though they were not passed. The fact is that they were submitted for consideration by their committee. In India, motions are actually so named in the standing orders, and the procedures are more defined and expansive than ours. And members of the Lok Sabha guard their right to file these motions both vigorously and jealously. And as an aside, I believe that given Indians' extensive and impressive judicial activism, which was referred to last evening, that this is one area that the Supreme Court of India would have struck down as being unconstitutional a long time ago, if in fact it had been so. In Australia, a country with a written constitution and Westminster-style parliamentary system, the Parliament, contrary to the opinion of some, has retained its amendment powers, whereas recently as 1995, a nominal amendment in the form of 250,000 Australian dollars were reduced to the capital expenditure. In 1994, in the United Kingdom's House of Commons, admittedly operating without a written constitution that is supreme, an amendment was made to a budget resolution which was carried by 319 to 311 votes. In Trinidad and Tobago, the relevant standing order number 67 is identical to Guyana's National Assembly's Order 76 and gives the House of Representatives the power to amend by way of a reduction. The fundamental point being made is that in all these Commonwealth territories, with a Westminster tradition and written constitutions, the power of the Legislative Assembly to amend is preserved. I turn now to the Chief Justice's preliminary ruling in Civil Action number 216W of 2012, Demerara. Much ado has been made about the Chief Justice's ruling in Civil Action number 216 of 2012. And far be it for me to use the speakership to exercise an appellate or review function over the High Court. But indeed, what is incontrovertible and needing of no debate is the fact that there is no burden or duty placed on this House to adopt or enforce rulings of the High Court Following on the argument of the Honourable Attorney General on this matter, I am not convinced that the High Court exercises a supervisory jurisdiction over the National Assembly. What I believe it can do, and has a right to do, is review decisions made by the National Assembly to ensure constitutional compliance. It has been previously indicated that the National Assembly will observe strictly the concept of the separation of powers, and with it, the recognition of the fundamental pillar that the National Assembly is in charge of its own procedures. The statement made in ruling number 3 of 2013, and that was a ruling given by yours truly, on the right of the Honourable Member Clement J. Rohi to speak and participate in the business of the National Assembly, still holds as valid. And I stated in that ruling, and I quoted, that the exercise of my duty should not be interfered with or fettered by the courts or be determined by the outcome of the issues before the courts, though we are both respectful of and grateful for opinions and interpretations provided by the High Court from time to time. Nonetheless, the National Assembly is legally and intellectually empowered and capable to work out its own procedures and settle its own issues. End of quote. Unless or until the standing orders are amended or deleted in toto, they must be recognized, applied, and upheld in this National Assembly. The standing orders provide the only procedure of this House. This House cannot, with the greatest of respect, be bound by a preliminary ruling of the High Court made in an interlocutory application for interim relief over and above its own standing orders, but can and does invite those with a deep interest in matters constitutional to engage the judiciary to provide a more final and definitive ruling on this issue as a means of providing guidance and interpretation for the House's fullest consideration. It has been suggested in this House that because the word amendment is not included in the Constitution's language, that the National Assembly cannot amend the STPs. This, in my humble opinion, is quite a quantum leap to take. If taken to its logical conclusion, its manifest absurdity is immediately evident. For indeed, Articles 65, 170, and 171 of our Constitution establish the Parliament's sovereign authority to make laws for the peace, order, and good government of Guyana. The National Assembly is a constituent member of the Parliament of Guyana. Nowhere in these articles is the word amendment mentioned, yet it is accepted as trite that the standing orders, and particular standing order 60, relating to amendments of clauses of bills are valid and applicable to every bill that is introduced into the House. We therefore cannot approbate and reprobate on this matter of the power of the National Assembly to amend bills brought before it for approval. The National Assembly has the power to amend any bill brought into the House, though in the case of financial bills, that power is circumscribed to be a power to amend by reductions only, except where a minister proposes an amendment to increase expenditure. Further, if indeed the House of Assembly has no power of amendment by way of reduction, then I posit that this would render the function of and necessity for the Committee of Supply obsolete, as it would have a simple robotic function of approving or disapproving the estimates, which in my view are a mere minute's work. The authors of the National Democratic Institute research paper that I referred to earlier captured this sentiment better than I could when they wrote, and I quote, "The ability to amend the government's proposed budget is one of the most direct and powerful means for legislation to influence national policy. In most countries, amendment power is considered a critical tool for enhancing the public's involvement, enabling effective oversight, bolstering transparency, and monitoring fiscal policy. Without the opportunity for amendment, legislatures become mere debating societies or lose ambition and simply rubber stamp legislation, thereby depriving the people of their most direct links to the governance of the nation," end of quote. And in the research paper entitled "Back from the Sidelines, Redefining the Contribution of Legislatures to the Budget Cycle," the author wrote, and I quote, "The power of the purse is an incontestable democratic fundamental. This also means that there is an obligation on the legislature to ensure that the revenue and spending measures it authorizes are fiscally sound, match the needs of the population with available resources, and that they are implemented properly and efficiently," end of quote. I turn now to Article 171, 2B of our Constitution. This article specifically states that no motion can be proceeded with that seeks to impose any charge on the consolidated fund, or for altering any charge otherwise than by reducing it. It is clear to me that the strict delineations of the separation of powers are maintained. The Honourable Minister of Finance moved a motion for the adoption of the estimates as is his constitutional right. The Honourable Khemraj Ramjattan, Member of Parliament, has proposed an amendment to that motion to reduce only, which in my view is done without crossing over into the realms of the executive by proposing increases. Article 171, in my considered view and opinion, allows for reductions by this House on any bill or motion introduced by the Minister responsible for Finance, any other Minister of Government, or by any member of this Assembly. Now for my ruling. Ruling, first, that the Constitution of Guyana is, as is every constitution, the embodiment of the nation's fundamental principles and provides the philosophical and guiding underpinnings of the state. It is through enabling legislation that constitutional provisions are given efficacy and effect. In this regard, the Fiscal Management and Accountability Act and standing orders of the National Assembly are the enabling legislation to give effect to the provisions of 171, 2A and B, Articles 217 and 218 of our Constitution. Secondly, The provisions of Standing Orders 76 do not, in my considered opinion, collide with, but rather complement Articles 171, 217, and 218 of the Constitution. Thirdly, the rules of procedures for the passing of finance bills are written and enabling laws that cannot be ignored or circumvented conveniently. Fourthly, the political system practiced in Ghana does not negative the authority of the National Assembly to amend bills and motions, including those dealing with public finance. Fifthly, the National Assembly of the Parliament of Ghana has the power to amend by reducing only the estimates of expenditures submitted by the minister responsible for finance. Sixthly, the National Assembly has the option of rejecting the entire budget or accepting the entire budget with or without amendments. Seventh, the power to amend cannot be used capriciously, injudiciously, whimsically, and or wantonly. The motion submitted in the name of the Honourable Member, Mr. Ramjattan, on the 12th of April 2013 and placed on notice paper number 179 of the same date is properly before the National Assembly and can be considered in and by the Committee of Supply. The aforesaid motion is compliant and not in collision with Article 171 2B of the Constitution and Standing Orders of the National Assembly. I'd like to say something on what I believe to be the way forward. In preparing for this ruling, it occurred to me that the easier part was in formulating a ruling, but the more difficult was pointing the House in a direction that is nationally wholesome. Those who gave and those who received the instruments of independence could never have intended that such a hallowed right and privilege of the National Assembly to amend the estimates that was fought for and won with much bloodshed and sacrifice many centuries ago would be usurped, surrendered, or easily given up. Correspondingly, such an important right must be used responsibly. Undoubtedly, the adage that with great rights come great responsibilities ring true here. The power to amend must not be exercised capriciously, vengefully, or wantonly, and without any rational basis. The preeminent duty of the National Assembly is to pass laws for the peace, order, and good government of the state of Ghana. In recognizing this right to amend, I believe that it will be exercised responsibly and within the spirit of the Constitution. To do otherwise would be to invite a court to vacate any amendments as being predicated on wrongful, unreasonable, and unconstitutional use of power. In my considered view, the minister responsible for finance now has two choices. When the Committee of Supply reviews the estimates and proposes amendments, if those amendments are adopted by a majority of the committee, then the Minister of Finance, when reporting to the House, may either report that his government accepts the amendments and want to report to the House that the estimates have been approved as amended, or he may indicate that he is withdrawing the estimates entirely as his government does not accept the amendments and see them as as an indication of lack of confidence in the government. It is for the government to make a calculated political decision as to whether it can live with the amended estimates or not. If it cannot, then the decision is obvious. In 2012, when the amendments to the estimates were proposed by the National Assembly and adopted by the Executive, albeit reluctantly, the nation did not fall apart. We have passed this way once before, and now have a better definition of what to expect, and we know that we can survive. The decision is ours to make, to embrace the realities and opportunities of the 10th Parliament, or to ignore them altogether. Thank you very much.